I had to do something. That is not much.
Good morning, Honorable. We are live. They are watching you live here.
Daddy.
Are you okay?
It's coming.
Mulimu ebyarayazi balina abakati mulina abantu basatu ejeko aliteke bali yali yesibayi nayo kulwanira okutandikirako oba okugendeza ye yesibira ku independent naye alina naye batikiti mulina babeka mulina musiru olajo
Haji, nsonyi okusumbuwa
asigale nga kirowooza mwageza okumpalansi mulina meya yanya naye musimu zitono bana abazi era wabona muzitono naye obulira mwangusa bwa meya ewamubeni yasinga ate mashinosi nazalibamba naye akizaala wembula kandi simulonda wawa musimulonda naye nsobola omwana nezaala okulawuasinga
Honorable, mbaleesanga okusitula mu katono wano olwabale
Gende.
Honorable, twagala okumanyako nga akwasaganya ekibiina ekivuganya gavumenti omu ku bakulembeze, tubulireko biki ebimu ku byosuubira olwaleero kuba twalabye dokita olunaku lw'eggulo ng'agattiddwako omusirikale wa UPDF nga baga nti naye y'omu ku be baakola emisango gino gy'okukwata ekissi mu ggwanga ly'e Kenya. What is your take about that?
Of course, kya buswavu kibali mu kugezaako okukola ekirabira ddala nti bagezaako okufuna engeri gye bagatika gino emisango kubanga Dr. Wezi ekisooka bamukwatira outside the jurisdiction of this court, bamuwamba buwambi ne bamujja mu ggwanga lya Kenya ne bamuleeta mu Uganda ne bamuteekawo emisango egyali giraga nti bagamba nti meeting zaatuula simanyi Switzerland, Kenya wa kooti eno terina buyinza kukozesa emisango egikoleddwa wabweru w'eggwanga. N'ensonga endala of course gye tuwakanya nnyo ya kukozesa basivilian mu kooti z'amagye. Kooti etaputa ssemateeka yavaayo olwedde n'ekyogerako bulungi nti basivilian tebalina kukozesebwa mu kooti z'amagye. Kakati kino kye bakoze kye baakola ne ku bawagizi baffe aba NUP. Tukimanyi bulungi bwe babawamba bano ba Olivier Altaya ne baleeta wano ne bakola ki? Bamala emyaka 2 mu kooti eno nga omusango gwe baali babataddeko gwakusangibwa n'emmundu. Emyaka 2 bwe gyayita ne babaleetayo omusango gwa treachery. Guno gwe bataddeko Dr. Besigye gwe bagezaako muteekako nabo ne babagattako ogw'omusango. Bano si bannamagye. Bw'osoma etteeka lya UPDF Act ogw'omusango gw'abantu ab'amagye. So kakati bano si bannamagye kati ne babongerako ogw'omusango gwa treachery. So byonna tubiwakanya nga bw'omanyi naye nga bwe nkugambye kati olaba baagala kukyusa charge sheet. First of all bongeddeko omusirikale, ekirala ne bongerako nti meetings ezimu zaatuula Kampala. Olw'obuswavu kati bagezaako okulaba tukitereeza tutya kino kye twakola bakimanyi bulungi tebalina jurisdiction oba tebalina buyinza bwozesa abantu ku misango gye bagamba nti bakolera bweru bw'eggwanga bakimanyi nti tebasobola kukozesa civilians kyova olaba bagenze ne bajjayo omusirikale eyo yonna yonna gye bamugye ne bamugatta ku fayiro eno so kiwakanya era ffe dimandi yaffe nga bolaba ebadde one bateebwe bano abantu kubanga emisango gye basooka bateekako clearly gyali tegiri within the jurisdiction even of any court in Uganda by the way sina kooti y'amagye yokka naye omuntu bw'asangibwa n'emuntu mu ggwanga lya Kenya ekyo kiba kitya obuvunaanyizibwa bwa kooti za Uganda yali badde akozesebwa Kenya kubanga Kenya nabo balina amateeka baali badde bamubuuza kale assuming nti emundu yagirina baali badde bamubuuza emundu eno wagifuna otya olina license yayo n'akozesebwa mu kooti za Kenya so si kooti za Uganda naye kyenkugambye nti eno pattern tugirabye abawagizi ba UNP abadde mu kooti z'amagye bwe bwe badde babayisa baleeta ne bagattako emisango emirala ne bakola ki naye ffe tuwakanya eno kooti eno n'okugiyita kooti obeera ogiwadde amaanyi mangi nnyo oba ogiwadde ekitiibwa kingi nnyo kubanga eno yali badde tribunal nga bwolaba disciplinary committee ey'amagye okukwasisa empisa mu magye naye basiviliani tebalina olunaku n'olumu kyebakola wano okiraba nti abo abantu abatuula mu kooti eyo chairman waayo n'abalala si banamateeka naye nga waliwo emisango ejanagomola wano oyo judge advocate abeerawo just ku advisinga ate naye emisango egiri serious bwe gityo tosobola gamba nti abantu baleete mu kooti bweti bagamba mu luzungu tutera nnyo gamba nti eno kooti prosecuting abantu wabula epersecuting abantu kubanga ekisooka gye no Museveni kati ye muwaabi ye complainant mu luzungu ye prosecutor ye muwolereza wa gavumenti ye mulamuzi kubanga bonna abenjogerako yaba appointinga kitegeera kakati bwobanga gwe judge gwe complainant gwe prosecutor oba osubira bwenkanya ki batambulira ku order
Aaron Kizza naye okukwatibwa wano mu kooti nga munnamateeka
of course Aaron Kizza kyali kikyamu nnyo first of all bwolaba ekibonerezo kye bamuwa bamugamba myezi 9 kimenya amateeka kubanga kati contempt of court osobola okusiba omuntu ebbanga eryo lyonna lyonna naye n'ekirala walaba Aaron Kizza tiyali abataddeko akaziso nga buli lwajja wano abakootingira amateeka constitution n'ebirala kati ne bagezaako okutiisatiisa banamateeka ne basala wali olaba nti kyonna baali bakipulaniza n'okumugana ogenda kutuula wali balooya abalala bwe baali kyali kipulaninge nga banoonya omuwaatwa gwe bagenda oyitamu okumukaba bamutwale mu nkomyo asigale eyo so ebyo byonna biviolatinga constitution violating amateeka gensi yaffe.
Honorable nga twogenzeeko ku nsonga eyakaviibwako emabega naddala nga econcerning ekibiina kyaffe kya National Unity Platform twalabye ebyatambudde bye twagala otutangaalizeeko ebyabadde Masaka okay, briefly in English ku byotugambye Honorable.
Yeah, so we condemn the continued detention and trial of Dr. Besigye and Advocate Besigye in the military court. The military courts have no jurisdiction to try civilians. So the Constitutional Court has been very clear on that point, that these courts are put in place to deal with discipline offences relating to the military, what they call service offences. They don't have any jurisdiction to try civilians, which the kizza Besigye is, and the other. Of course, by amending the charges to add a soldier, they are trying, now they are ashamed, they are trying to figure out how do we bring them within the jurisdiction of the court, and trying to say that some of the meetings sat in Kampala. Because as we have been saying, if people are found with a gun in Kenya, the courts in Uganda have no authority whatsoever to try that offense. Because there are courts in Kenya, they should have handled that matter there. If he had committed any offenses in this country, they should be tried in civilian courts, certainly not in military courts. So we condemn that in the strongest terms possible. And of course, we have been very, very categorical that Dr. Besigye should be released and his court. if he committed any offense in Uganda, he should be tried by civilian courts. The reason why General Museveni loves using these military courts is because he is the prosecutor, he is the judge, he is the complainant in most of these political cases. He knows that he has full control over them. He appoints the judge advocate, he appoints the chairman of the court, he appoints the prosecutor, all these people are under him. So if all these people are serving the interests of General Museveni, then how can there be justice in such a matter? And yet you see they are trying to add grave offenses. This, what they have just done, happened to NUP supporters. Because when our supporters came here, they initially were charged with unlawful possession of ammunition and all that. After 2 years in detention, they amended the charge sheet to add treachery, which is a very, very serious offense, which is akin to treason. So they added that to, so you can see that this is just not prosecution, but persecution of the opposition, persecution of those who are opposed to the Museveni regime.
And then Counsel Aaron?
Yeah, for Counsel Aaron, we condemn the manner in which he was violently arrested, and of course given a very, very harsh sentence, which is unlawful. You saw that it was clearly choreographed, because Aaron Kizza has been very, very categorical about this court, saying it's not even a court, it should be a tribunal, talking about the law, the right to representation and all these things. So I think they were trying to find a way of dealing with him after several times trying to suppress him, and he was not, budging. They decided to use this very court to send him in detention, which is unfortunate. You can imagine where you have lawyers coming to represent you and they end up also being taken to court, to jail. So it's very, very unfortunate. And we join all those who are demanding for the unconditional release of Advocate Aaron Kizza, because what happened to him was the epitome of injustice and impunity.
Thank you very much, Honorable. That is Honorable Secretary General of the National Unity Platform. As you see him, is from giving us a press brief about how it will happen. Uncle Nancy, unanyambako n'ompereza kopako kabiri. Unanyambako n'ompereza. Badde light.
Tate bwe mbanka kozesezza ate onaabanga kozesaawo. Onaabanga kozesezza.
Ngamba. Tekali mu simu. Obadde naawe oli live.
Anti nze nenda kakozesa online.
Ajja simba nenyagala kakozesaako katono. Awo omanyira sharing. Yes, briefly, I was trying to tell you about counsel. Like you've seen him. He's been talking about a lot of issues, and also Counsel Wanda. Good morning, sir. Counsel, briefly, yes, we are live.
Thank you so much. Yesterday, as you noticed, the state wanted to amend the charge sheet. As you be aware, we've been waiting for particular ruling. Why? And yesterday, instead of giving us that ruling, it was challenging the jurisdiction of the military jurisdiction, trying someone who has been arrested from a different country, offenses allegedly committed in a different country, and trying them here. That's what we were challenging. To our dismay, the ruling was not read, but rather the state tried to amend the charge sheet, including another offense, and also adding serving someone to the offense. And of course, our argument was the moment you amend the charge sheet, those are new charges, and therefore someone has to take a plea afresh. But again, there are regulations, Regulation 23, gives an accused person to raise an objection even before taking a plea. So we spent a lot of time on that issue. For the first time, the judge advocate did not want to refer to their own regulations, and they wanted to proceed without them by reminding us that the person has taken a plea. But later he succumbed to our demands, and then we were given an opportunity to raise objections with regards to the same charges, on the issue of territorial jurisdiction. We believe Uganda has boundaries within which we can try and charge people for certain offences. We don't believe that offences are allegedly committed in countries like Switzerland, Greece, and Kenya. Uganda has the jurisdiction to try them. We understand that the EPDF gives them powers to try them committed outside Uganda, but the intention was not for any offence committed outside Uganda. The intention was for offences committed by servicemen while outside of Uganda. You realize that Uganda has soldiers in places like Mogadishu, in Central African Republic, in DRC. Now, when a soldier commits an offense, a service offense, even when in that country, then the Ugandan law, the Ugandan territorial jurisdictions, has powers to try such a person. Because a base in Mogadishu can be considered as a base within Uganda. You're a soldier in Uganda, so you're just an attaché there, but not the entire territorial jurisdiction. So we believe that the court does not have that jurisdiction to try anyone for any offense committed out of the country, except with those few exceptions, which should be modified within the Act and not any other offense. So those were the arguments we raised, and the state responded to our arguments, and indicated that even if there was no extradition, that they have an MOU with Kenya, which we believe totally violates the laws, international laws, because you cannot claim that you have an MOU that allows you to just pick someone from wherever they are and bring them and charge them here. And also there was no proof that that MOU actually exists. We believe that the state, in trying to refute our argument that the bringing of Dr. Kizza Besigye and Ajobedi Ntale into the country was a violation of international human law, then they should have taken such a memorandum before court to confirm that indeed what they did was illegal. However, they didn't have that, and they were instead telling us to prove that the government of Uganda doesn't have an MOU with the government of Kenya on how they should deal with cross-border crime. And we also believe that what they are being charged of is not cross-border crime. Cross-border crime is definitely, it's defined. Things like terrorism, things like money laundering, those are cross-border crimes because they may not necessarily be committed within the jurisdiction of the country. But the crime of having a pistol, a crime of having ammunition, that cannot be cross-border. Because in other words, if I'm a resident of Kenya and I'm a citizen of Uganda, if I have a license to carry my gun in Kenya, then Uganda cannot make it an offense in Uganda. So it doesn't come to the definition of what we call transporter crime. So today we are waiting for the ruling on those objections that we raised. We believe the chairperson could not make a decision at that point because of one, the extreme legal arguments we had, and as we all know that the chairperson is not a lawyer or someone qualified to be a judge, so probably need to consult with the judge advocate so they can come up with a ruling. So today morning we expect to have a ruling from the General Court Martial on the objections we raised, and we hope that the objections can be sustained and the accused person is charged from this court.
Any updates from Counsel Aaron Kizza? Because we saw yesterday it was all about Colonel Kizza Besigye, and you raised some issues about Counsel Aaron, and they said he's sentenced and you know what to do.
Yeah, see, once sentence has been handed down, there are other various mechanisms that you can use to deal with a particular sentence, and I can confirm to the authority that a legal team is handling that issue. We have several legal teams which are handling that issue, headed by some of the senior legal practitioners in this country. Some documents were filed yesterday here at the General Court Martial, trying to appeal that particular sentence because one would believe it was extended legally out of context, because we all know that an advocate who is charged with contempt, the maximum penalty they can be given is 30 days. So then there are other mechanisms we are using. Applications have been drafted and they are ready, and we're hoping the same can be signed by him today, and then we can have them filed in the other courts by tomorrow morning.
Briefly, in Uganda Council, okuva gye twatandikidde.
Olunaku lwajjo ekyabaddewo kooti oba omwezi wa gavumenti yagezaako kukyusa mu mpaabanye kyetuyita amended charge sheet nga ku ekyo bagasseeko omusango omulala oba n'ekirala ne bagattako omwawaabiri omulala munnamagye ali ku rank eya captain bamuyita Ola Dennis. Naye amateeka gafuga kooti eno gagamba musinga omwabirwa yenna alina kyatakiriziganya nakyo naddala ku jurisdiction waddembe obutaddamu ansa ku musango ogumusomeddwa either okukkiriza oba okuweegaana, era nga kooti emukkiriza okusooka okuteekayo okwemulugunya kwe ku kyetuyita objection to jurisdiction. Twakireese jjo naye omuntu awabulaga kooti eno gwe advocate yagezezaako nnyo okwebalama okugoberera etteeka eryo, era twagenza okukkakkana nga kooti nga yeekasseeko yennyini n'asobola okukigoberera era nakkiriza netuteekayo okusaba kwaffe muno emisango gino gyonna ebivunaanyizibwa gyaddizibwa bweru wa Uganda, ate gavumenti ya Uganda teyina lukusa lutwaye nga omuntu yenna ku misango egibagirizibwa bweru w'eggwanga. Omwabi wa gavumenti yazzeemu mu kusaba kwaffe n'agamba buno balina ekiwandiiko kyetuyita MOU wakati waabwe ne gavumenti y'e Kenya naye tebasobodde okitulaga oba okiwa kooti. Era olunaku lwayo tusuubira kooti egenda okuwa ensala yaayo ku objections twaraisinze oba ekyasobola okuwuliza omusango guno oba nedda.
Tweyanza nnyo counsel, tweyanzege. Counsel.
My dream is to see and stand
Counsel, good morning. You're welcome. Today, what should we expect?
We are expecting a ruling. From there, we will know our
Counsel, good morning. Good morning, Counsel. We shall get a little bit of talks here. I will give you a little bit of talks from different dignitaries. Basically, we are the court martial right about now. Counsel Martha Karua has just arrived, as you see the picture over there. It is all about different people reaching out here. It is the team of the councils who are going to represent Kizza Besigye. It is the full team of councils. As you are watching us, subscribe and we make it happen. The team of, it is a number of 40 plus. It is a number of 40 plus. Council area Surukwago, Council Martha Karua, and she's coming for presidency. We shall get an exclusive with her in a little bit. That is Council Martha Karua, as you are seeing. Some papers are thrown down. Over. Chabasa. These are some of the councils and the team. Deputy, only 1 minute. Good morning, Deputy.
Good morning to you.
What should we expect today?
Well, honestly speaking, like I stated, for me, I'm not expecting miracles. And I think what transpired in court yesterday communicated that these people are determined to hold Dr. Kizza Besigye. They are determined to hold the Hajj Obed Kamle there for some time, not for a short time, but for a very long time, because the charge sheet was amended. A serving UPDF officer, Captain Dennis Ola, was added on the charge sheet. And for me, specifically, what triggered my mind is that the new charge sheet includes Kampala metropolitan area. Initially, they were saying they committed these offenses in Greece, in Switzerland, and in Nairobi. And our argument as supporters and also the argument of our legal team was that this court does not have jurisdiction to try them. Now they have added Kampala metropolitan. That means they are going to say Machinde court martial is in Kampala and therefore they can try these people. So I do not have any hopes. But like Besigye has always encouraged us, we are fighters, and under dictatorship, whatever Besigye is being subjected to is expected. Whatever Aaron has been subjected to is expected. But I've told people, we are fighters. I know this time round, we have received some blows, but trust me, we are going to fight back. We are not going to simply watch as Besigye stays in prison. We are not going to simply watch as Aaron stays in prison, because it's not about them, this is about us. When Aaron came here, he did not know that as an advocate, he was going to be put in the dock, he was going to be tortured and remanded. So this is equally for us to fight for the legal team. This is equally for us to fight for any other person that might fall a victim to the wrath that we are being shown at the court martial.
Thank you very much, Deputy Lord Mayor. It's not so good in Luganda.
Sina kyamaanyi nnyo kye nsuubira okuva mu eno kooti, kubanga ebyabaddewo oba ebizze nga bibeerawo mu kooti mwena mubadde muliraba bulungi. Jo twabadde very surprised gye bafulumiza charge sheet nga bongeddeko kati omunamagye gwe bayita Captain Dennis Ola. Nsuubira ne Dr. Besigye ne Obed ono omusajja tebamulabangako. Tubadde tuzze nga twemulugunya nga tugamba ebikolobero bino byeboogerako babikomitinga e Greece, ne batugamba e Nairobi, ate ne batugamba ne Switzerland. Naye jo bayongeddeko omusango omupya ate ne batugamba gwali committed mu Kampala metropolitan. Kitegeeza kati eno kooti enoonya legitimacy etugamba nabo balina obuyinza obusobola okutryinga Dr. Besigye. So ffe tetujja kugwamu mwali, era tugenda sigala nga tulwanira eddembe lya Besigye, tugenda sigala nga tulwanira eddembe lya Aaron Kizza, kubanga tukimanyi leero batutaawo naye naffe bagenda tukiwa.
Thank you very much, Counsel. Sorry to call you Counsel, Deputy Lord Mayor over there. Lois Lubongoya is getting inside, as you see. Lois Lubongoya, as you see, is getting inside. Counsel Elias Lukwago is over there and also getting inside. Yes, beautiful viewers. Today you're not telling me where are you watching from. It's better you tell me where are you watching from. I kindly read the places where you are watching us from. So to get a this Senior Obedi kintu kino naye waali nnyo anti ffe twakoze live. Oli omwana wa BTM wa credit yange yaleetebwa. Good morning, Afande. Morning, Afande. Good morning. Okay, right now we are in the court. You finally entered. Yes. We are in the court right now. As you see, everything finally entered. Ajabu. They don't go in Mavika Ajabu. Anti ajabu wali wano. Ajabu sinza munyigiriza ono satya oyagala ngobe mu kifo ono sebo gye nkolera sijakolera naye angobya bwe kiri ajabu gwe obeerawo nga tomanyi maanyi go gonna naye okuba bukubi kasimu nti oyo musaba fired. Okay, today we are not delayed to get inside. Nelson, are you subscribed from Kabale? Over, you are not yet subscribed. Yagadde nti kituuze kigaziwa kituufu. Simon from Muntungamo, I see you, my brother. Thank you for watching. People from US, subscribe. The goal is all about start earning something here because we are so hardworking. We are so hardworking. From Mumbalala, Joseph Kanungu. I thought you are already inside. I'm already inside. What do you see? You think? Pastor Daniel. You want to see from Mumbalala City. Simon from Serere. Wiki Peter Simon from Serere District. Well done, bro, for the nice work. Thank you for appreciating. I'll see the appreciation here. Subscribe. That's how I can get your appreciation. First, subscribe. If not yet, subscribe. Nairobi, Kenya, Ndugu. Thank you for watching Ndugu from Nairobi, Kenya. How are you doing, my people from Nairobi, Kenya? We are also Emmanuel from Busenke. Emmanuel from Busenke, free our president. I'll get a little bit here of an interview from Moscow. Yes. William Bush. Basajja abatulaba bali Moscow. Waliwo n'abali ewaffe wano naye nga abasinga balala nno. Shema. Tapu screen byabali abatikiro. Wano twagala subscription. Tubuulira gy'osinzidde kiba kimala. Moscow in Russia. Mumana kuba n'omuntu ng'ali Russia. Should we expect an opposite outcome? You never know. It will turn around and come around. You never know. Today the volume is clear. Thanks. The volume is always clear, my followers. It is all about you supporting me. If you can easily support me to get good microphones, they are 150. I'm trying now it's been allowed. It's been data only Kampala kumugaga senfuma wano. Bone kamera zo. Nimulaga senfuma wano bakama bange bole mulisa o kamera. Wano na babichi. Innocent Joseph senfuma senior. Ayagala ekintu kimuse. Senfuma. Zena kukolako obukaba wake. Nina is from Champ. Your contact, please. My contact is 0787 103 136. My contact is 0787 103 136. Obo Henry, yes, thank you. Mr. Obo Henry, thank you. My contact is 0787 103 136. My contact is 0787 103 136. I'll be happy seeing here a message for any refund, any help, any push-up. I need microphones for only 150. Yes. We can get better sound more than this, but any help is all about 0787 103 136 in the names of Musa Sewankambo. Straight. Let me try it. All right. Keep it up. Just push it up and subscribe. Masidi, where is that place? If you're watching us, you can easily tell us where you're watching from. We are waiting for Dr. Kizza Besigye to get inside court. For those of you who need my contact, is 0787 103 136. It is 0787 103 136. I will be so happy to see something here moving loud and clear, watching from Juba, South Sudan. Honorable Kenny Luchamuzi is also here, watching from Mombasa, Kenya. Thank you for watching. How is Kenya doing? Masindi. How is Masindi? I see you guys. Masindi, who is that? Kahawa. Thank you for watching, guys. Hey. Honorable, good morning, sir. Only 1 minute as we are waiting for Kizza Besigye. Tell us about this army soldier who was added on the matter of Kizza Besigye. What is your take about him? Do you see, or was he among the suspects?
Those who got in the case were mapping out a strategy of extending what Dr. Besigye bring answer. Otherwise, in terms of rules correlated to the rules of the court, that kind of submission is not acceptable. And I think that's why it's very because of this case yesterday. This case has two important elements to look at. One is the territorial jurisdiction, which has got to be solved or measured from the entity of territories and the sovereign territories. The second one is related to the municipal jurisdiction, which carries the Kabazuka case, which has been decided recently by the
Yes. That is Honorable Kenny Luchams for you. There is a message here. It is kind of jokey. You know we are live. The message is like they need some language that you used to talk to them in this matter. Thank you very much, Honorable. That is Honorable Kenny Luchamzi for you. It was kind of jokey, but olulimi achalumanyi bubinyate. Hello, good morning, sir.
Good morning.
Yes, a little bit of what transpired yesterday and what do you expect today, basically. And we saw a soldier added on the matter. What is your take about that?
Well, everything wrong is going wrong here, and we're here to right the wrongs. And our expectation is that we're going to get something good out of the judgment. It's crystal clear that this is an illegality in waters and criminality, and also appreciating that it contradicts every law structure, every law system. Talk about national laws, talk about regional laws, talk about international laws. Yeah, so in addition of the other individual, who is now part of the original case, certainly also sends a signal that this is the use of tramp churches, but they have been caught again. We're not living nothing to chance. This is I know there are doctors in the entire system, people who believe in the prosperity, unity, and the progress of this country will put their time and effort together to help Uganda get a better start. We're in this together. First of all, we want to thank our brothers and sisters, in Kenya that are standing in solidarity with us. Their work is to own the regional spirit and the regional family, to know that an attack on any one of us, an attack on all of us. But also we expect that, as a country we've gone through enough, and we feel this is the right time for us and for everybody to say enough is enough. It cannot be business as usual, and I'm happy that everybody, including those that support the system, are getting to a point where they're appreciating that, look, this is not going to be a business or years of error, just like you had from the proceedings yesterday. A court order, an MRU, extradition treaty, and things that border to the international law system have been working. And I believe that these people have run out of excuses. And I, towards that today, they have an option to give us a judgment that is in our favor, to allow activists and those that are incarcerated, illegally detained, to get their freedom today. Because just like very finally, just like it is crystal clear that if you claim or you report that somebody committed a crime while in Switzerland or Kenya, there is no cop in Uganda under the sun or underneath the sun that has the constitutional power, constitutional influence, and constitutional authority to even hear, not even the top of this process, but even hear, not the Supreme Court, not the Constitutional Court, not the higher court, the High Court, or such courts in Uganda that are sanctioned for an act of politics. So this is an illegality, and it's going to be passed, and for the low garbage bin that we deserve today. And basically, that's what I believe is gonna be the outcome, and that is the expectation that we have today.
Thank you very much.
Appreciate it. Thank you so much. Appreciate it.
Gugudde nsaba kuyitako kalabe mukono wange akwasibwa kabikula nekyalirayo kakuyiteko kateredde gusa abasajja bagenze ne bagisaako layivu yange n'abantu ne badduka bagisizaako kalayivu kange n'abantu ne badduka naye bagenda kudda tubadde mu bantu 3. Somebody told me here that he had sent me something, but I haven't seen any message. He's from South Africa. He had told me he had sent me some support here to buy microphones. You know, they are telling me we are not getting good sound. I had told them microphones are 1.5 only. So we are in a goal of getting microphones. This kangaroo kooti is fake. Gambo byammwe sagala byogera. Omwana wuno message yagiwandiise. Labayo kitimba. Alright, ladies and gentlemen, we are waiting for the chairman of this court. After the chairman getting his side, we wait for Dr. Kizza Besigye. As we are waiting for Dr. Kizza Besigye, we shall be waiting only the ruling to proceed with the matters. Otherwise, for those of you who want to support through the mobile money, it is 0787 103 136. 0787 103 136. Chairman is already in 7.
state. Yes, Kano Lieutenant Second Lieutenant Anthony Phillips Rupert, and Second Lieutenant Regina Manza.
Mr. Secretary Julius Paul, Mr. Samuel Muizi Mulindwa, Mr. Ivan Bowe. I think that is the list of council that is present this morning.
We are ready to receive the report.
Republic of Uganda, Uganda People's Defense Forces, the General Court Martial of the Criminal Case Number 86 Series 2040 of 2024. Uganda versus A1 Arab Hotel 74 Captain Dennis Mora, A2 Arab Hotel 0098, and Octave Dr. Kizza Besigye. A3 has prepared the target. A ruling with the court and objection raised to amend the charge sheet. On 13th January 2025, Colonel Raphael counsel for the state applied to amend the charge sheet by adding Captain Dennis Mora as the third accused person under possession of the arm. When it came to pretending, counsel for Colonel Dr. Kizza Besigye, led by Martha Karua, Elias Lukwago, and Ernest Malibara, raised the following objections in the back of his trial before this court. That this court has no territorial jurisdiction to entertain charges that were allegedly committed outside Uganda. That the charge sheet was defective because it was not in accordance with the UPDF Act by mentioning defense forces. That is not clear as to which defense forces were referred to. But how the accused person was brought before the court did not follow the due process of the law. Our counsel cited this court, the case of Omar Awad Omar and 10 others versus Attorney General Consolidated Constitutional Petition number 55 and 56 of 2011, and submitted that the accused person was illegally brought here from Kenya to Uganda, having been abducted. That section 208 and 209 of the UPDF Act that appears to grant the court jurisdiction contravenes Articles 79 and 129 of the Constitution. The counsel prayed that this court finds merit in the objection and discharge the accused person. In reply, Counsel Raphael for the state submitted that the jurisdiction is a creature of the statute, and therefore Section 208 of the UPDF Act gives jurisdiction to this court to try the accused person. Our counsel further submitted that the words defense forces are defined in the UPDF Act to mean Uganda People's Defense Forces, and therefore the submissions of counsel to the accused are misconceived and should be ignored by this court. Our counsel further submitted that Section 117G on aiding and abetting, and H on being found in an unlawful possession of arms or ammunition brings the accused person before the jurisdiction of this court. Counsel further submitted that the accused person was brought lawfully through the memorandum of understanding between Kenya and Uganda on interstate arrangement on defense and security for offenders involved in committing who suspected to have committed serious crimes like terrorism, among others. Our counsel further submitted that the constitutional provisions cited in this matter are not applicable. That is Article 23, 28, Clause 7, 12, 126, 129, and 79. Counsel further submitted that there is no decrease in the charge sheet as alleged. In the rejoinder, counsel for the accused submitted that in the case of Omar Awad Omar, the Tanzanian case of Mataka versus R was distinguished. Counsel submitted that in a number of cases cited in Omar Awad above where there is evidence of abduction, then the court has no jurisdiction to try the accused person. Lastly, counsel retaliated earlier prayers that the court finds merit in the objection raised and discharges the accused person. This court, after listening to the submissions of both counsel for the accused and the state, considered the relevant laws relating to this application as deliberated on this application and finds as follows. One, that jurisdiction is a creature of statute and section 208 of the UPDF Act gives powers to this court to try any person who has committed an offense in Uganda and outside Uganda. Two, that there is no defect in the charge sheet because the accused is charged under Ugandan law. Under Ugandan law, the UPDF Act, which act clearly defines defense forces to mean Uganda People's Defense Forces. Three, on the submissions that the accused person was abducted and brought to Uganda without following due process of the law. This court finds that there is no extradition treaty between Uganda and Kenya that was breached. To the contrary, this court finds that the accused being brought to Uganda through a memorandum of understanding between Uganda and Kenya on defense and security for purposes, for persons suspected to have committed serious crimes did not amount to abduction. This court has considered the consultations of the Constitutional Court in Omar, and others which were cited by the counsel for the accused from paragraph 25 on page 63 to page 74 of the judgment and entirely agrees with the court. For on the submission that section 208 and 209 of the UPDF Act that appears to grant this court jurisdiction contravenes Articles 79 and 129 of the Constitution. This court finds that it is not true that section 208 of the UPDF Act appears to grant jurisdiction, but actually gives jurisdiction to this court to try the accused person. Jurisdiction being a creature of the statute, and this court having addressed itself to the provision of Article 79 and 129 of the Constitution. This court finds the cited articles not applicable in this application and finds that this court has jurisdiction in the case. Accordingly, the objection raised are hereby dismissed and the accused person should take bail. We so rule done at Makinde this 14th day of January 2025 under my hand and seal of this court. And with that, we are proceeding from where we had stopped yesterday to Kano Dr. Kizza.
May it please you, gentlemen. We have a matter of law to raise.
About the rule?
Yes, Mr. Chairman. And Mr. Chairman.
All done, counsel. Counsel advising that.
they may be allowed in such a amount. It's a matter of law, it's a matter which touches the Constitution. So we have to prepare to make Mr. Chairman.
And that's why this is my advisor. It's about let him advise and then
Mr. Chairman, the issue is about making the prayer for constitutional reference, and we tell them to be permitted to do so, Mr. Chairman. And if it's a matter of constitution, it takes precedence over any other issue. And that's the reason we are seeking for the audience to permit us to make a case for a constitutional reference led by my colleague here, counsel. That is our plan, Mr. Chairman. We make a case for constitutional reference. And if you do permit, counsel Kalibara will proceed to take it in light of the ruling of the Mr. Chairman. And I would like to emphasize that where a constitutional matter has been raised, it takes precedence over any over any other matter. So we beg that you permit us, Mr. Chairman, to proceed, argue out the case for constitutional reference.
I have no problem with your submission, counsel, but what I'm saying, he advises the court on law matters which you are going to raise. Finish the ruling, let him advise, and then we will be given time if it is allowed. I don't know what you are laughing, and I don't understand what it means.
I think, sir, if he has any points to raise on the matters of law, the procedure is that you can add out your case, the state will respond, and this court will also rule on that matter, whether what you have raised requires the reference to the constitutional court or not. So you can proceed.
I wanted just to know why are you laughing? Hold on. Unless you don't know his law, maybe he has advised. That's what I want you. I think the council can do it.
Thank you, Mr. Chair. Honorable members. Following the ruling that has just been delivered, our instructions are to seek for a reference for a number of matters. The ruling has itself interpreted articles of the Constitution, found them inapplicable. That role is a role that is reserved for only one court in this land, the Constitutional Court. But Mr. Chairman, I want to preface my application for reference by taking the court to Article 208 of the Constitution. That article, Mr. Chairman, establishes the UPDF. And it spells out a number of very good attributes for the UPDF: patriotic, professional, discipline, and so on. Those attributes, in fact, distinguish the UPDF from other class post Besigye. So they are quite professional, questionable, they're quite useful. I think that they are amazing attributes to have. I have found them also on the UPDF website. So the UPDF itself is aware of what these attributes are. One of the most important attributes in Article 208 is that the UPDF is subordinate to the civilian authority. Established under the Constitution. Mr. Chairman, what that means is simply that the force, its members, and its organs are all subordinate to civilian authority. In fact, the courts, referring to a number of cases, the courts have made pronouncements to that effect. And we contend that in the finding that you have jurisdiction in this matter, the General Court Martial is putting itself above civilian authority. And I'll explain what that means. Mr. Chairman, our Constitution is a very, very important document to us. The preamble tells us all the things that were wrong in this country. It tells us the things we aspire to. And it also says these are the ideals we should pursue. In saying so, it wasn't about 1995 when it was promulgated, but it was to continue up to eternity. That same document also gave us chapter 4, which covers many articles of human rights and so on. I'm going to refer to 28 shortly. But the force, the UPDF, must live by what the Constitution declares. In addition to what I have just said, that same Constitution says that the rights of are inherent, so they are not granted by anybody, not any organ, not any person. They are inherent. And they can only be taken away in the manner that the Constitution has said they can be taken away. So I will start with Article 28, the right to a fair hearing. Honorable Chair, the right to a fair hearing has been described as that Article 28 as a culmination of Uganda's struggles against forces of tyranny, oppression, and exploitation that brought about unconstitutionality and political instability. It is one of those articles that cannot be derogated from. So there are no circumstances at all under which one can ignore or disapply or fail to observe that specific article. One of the most important aspects of that article is in Article 28:12. Article 28:12 provides an except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed by law. The emphasis is on the defined, which is what we are dealing with. So Article 2812 requires that every offense is clear. The idea around definition is that when you read it, you know what conduct amounts to an offense and what conduct does not amount to an offense. And it cannot be derogated from. So if we have a situation where it's not clear, then we are derogating from Article 2812. Mr. Chairman, the charge sheet has an offense which is described as offenses related to security. It is contrary to Section 128, 1F of the UPDF Act. Perhaps if we read it out, paragraph F is to the effect that if you do or omit to do anything with intent to prejudice the security of the defense forces, you commit an offense. If you do or omit to do anything, so walk into, as a civilian, I walk into a military barracks. I could be charged with offense. I could be charged with offense. If I am a cook and I decide that the porridge I have been asked to make for this morning has, in my assessment, issues, and I refuse to make the porridge. As a result, people go out in the unit and they are hungry, they are ambushed, and they have no energy to fight. I can be charged with that offense, and I can be put to death. That is if I refuse. If I don't refuse and I make the same porridge, knowing that the portion may have an issue, but we have to eat, people have to go outside, and people go out and they will not running stock. I can be charged with that offense. If you do anything, if you omit, now, Mr. Chairman, it would be useful if the court looked while it's considering this application. Look at the rest of the paragraphs, 128(1)(a) to E, because they are very specific as to what it is a person could do. Disclosing by word of mouth the document, information to the enemy, that is clear. Discussing confidential information, giving a password to somebody who's not authorized. And then at the end of that whole section, if you do anything or omit to do anything, Mr. Chairman, I contend offense is not defined. Article 2812 deals with gist of it. The purpose for it is to ensure there is no vagueness. So it is a constitutional standard to deal with vagueness. And why is there a problem with vagueness? Is simply because you can have overreach. The application of the section depends on the whims of the person who decides that it applies, it doesn't apply. The gentleman making porridge, I maybe have to hold it up in the air shouting that I have just disarmed this person, I'm not committing an offense. This is a big problem in our assessment with that provision. So, Mr. Chairman, it is the contention of the accused person that offense is written in words that clearly show that the people who drafted it had run out of the clarity. Then they just said, let's just also put a net and see what else we can catch. We want to catch Nile perch, but let's put a net. If we also get mokene, we get worms, we get stones, it's okay. Let's just try. But the whole intention was we wanted to get Nile perch. So, Mr. Chairman, honorable members, it is our contention that there is a question that arises with regard to section 128, 1F. The question that I will pose to the court is simply this: whether that section 128, 1F of the UPDF Act is defined in terms of, and therefore consistent with Article 2812 of the Constitution. Honorable Chairman, the General Court Martial cannot answer that question because, as I said earlier, the role of answering these questions is the preserve of the Constitutional Court under Article 137(1). We trust that the Court Martial is part of the UPDF, the law-abiding citizen institution, which is why I refer to the attributes of the force which must be professional and disciplined, and is aware that it must subordinate itself to the provisions of the Constitution, will find this question one that we will prefer for interpretation. Mr. Chairman, there is another question that we would like to also pose. And it's a question that has arisen here, but continues. And it is so fundamental to the trial of especially the two civilian gentlemen that it's imperative that it be addressed. Mr. Chairman, again, Article 28, Sub-Article 1, spells out the standard that is expected, that is required, from which there can be no derogation as far as a fair hearing is concerned. Fair, speedy, public hearing before an independent and impartial court. Independent and impartial. The cases, Mr. Chairman, that have dealt with the issue that I am addressing you on, the trial of civilians, are many. Captain Amon Yagaba is one such case, 2015. Attorney General, Uganda Law Society versus Attorney General, 2005. Attorney General Joseph Mushabe, 2005. Michael Kavaziguruka, 2016. They have all said the same thing. And that thing is that with the setup that exists in the structure, this court, it is impossible for there to be a fair hearing. They have addressed questions of independence, they have addressed questions of impartiality. And I say this, Mr. Chairman, with all the humility I can, all the respect, but taking you back to the attributes of the force being subordinate to civilian authority. The judiciary has said this is the position. Then the force and its orders must subordinate themselves to that position. Because to do otherwise, Mr. Chairman, is to say that the force that is organized, that the officers and men, the wonderful officers and men that constitute that force, can rise above the Constitution. If that route is taken, if that view is entertained, if that thought even crosses the mind of anybody, then the entire 150 words of the preamble that I spoke about are useless. We get right back into Chile. You must distinguish yourselves from those forces that do not abide by the Constitution. Mr. Chairman, in light of those decisions, the ones I have cited, and I know Land Fred would say one of them had a stay. It is true, it has a stay. It is a stay on implementation, not on interpretation. When you read Amon, Captain Amon Yagaba, the court there was very clear. Until the ethics court has pronounced itself on the interrelated issues, the paragraph dealing with Kavaziguruka. Michael Kavaziguruka, Attorney General, as well as ULS and Attorney General, both of which I have cited, remain good law for the present purposes. Mr. Chairman, the law now is as interpreted by a constitutional court. But we can't be here to deal with this. Even if we want to, we can't. We can't. Unless we are elevating ourselves above the Constitution. If we are, then we can be here. But if we are not elevating ourselves, then we must abide by what those decisions say until there is a contrary decision. There is no, the stay, I'm sure my land friend will refer to it, the stay does not remove the interpretation. And the importance of the Constitution, I I don't know what words I can use to express how important it is to abide by the Constitution. Mr. Chairman, the question I would like to frame and propose it be framed is this: whether in light of the decisions of civilian courts, both the Constitutional Court and the Supreme Court, regarding the trial of civilians in the court martial, the conduct of the General Court Martial as an organ of the UPDF to try two civilians is consistent with Article 2082, the one being subordinate to civilian authority. 128(2), Mr. Chairman, 128(2) is that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure the effectiveness of the courts. Effectiveness of the courts includes its judgments being binding, being applicable to everybody until there is a contract position. Michael Kaba's group was decided about 4 or 5 years. There has not been a contract position. I would pray, Mr. Chairman, that question also be allowed. We had proceedings still in Article 28, 1, on the impartiality, on the nature of the tribunal, and there is a question that arises about how impartial tribunal, organ of the defense forces which investigates an offense, charges accused, tries the accused, can be considered impartial in any way. And this is not to say anything about the character of the fine officers and men who constitute. It has nothing to do with their institution. How can you be a judge? What? How else can you find prejudice other than being a judge in your own? The church tells us about offenses related to defense proceedings, the defense proceedings. So when we ask that these matters move away from here and go elsewhere, we are simply following what the Constitution requires. Yesterday we had these engagements with the judge advocate. Good friend. But from this side and that side, we're always having contestations. Just for purposes of impartiality. The panel, and also yesterday we went through what the panel consists of. But we found a regulation, this is just an example, Regulation 69. So yesterday we had an issue around the judge, whether his views are binding or not, advice given and so on. I'll address that shortly. But there is also another one which I want to give by example. 69.2 says that A court may adjourn, it is referring to the court martial, may adjourn at any time to consult the convening authority on the point of law. This court is supposed to be complete as a unit, discharging its work alone. Everybody who is a member of this court should be in the court. I checked who the convening authority is. It's the High Command. Now, if a court will adjourn or can adjourn, or is empowered to adjourn, or is allowed to adjourn to court, consult the High Command. Mr. Chair, Article 28(1) would have no place. But this regulation cannot apply above Article 28. Impartiality. So, we also pose this question. In the circumstances where we are, where the defense forces are the complainant, the investigator, the witnesses, the judge, it's a trial before the court martial consistent with Article 28. Is it? Can it be submitted? That question needs to go for interpretation. There are other factors dealing with impartiality. They have to do with the tenure, security, and so on. So in the other civilian side where we are made a little bit more familiar, we know that there is sanctity. There are provisions are protected that reinforce, protect the judicial officer, reinforce the idea around impartiality. No, we don't. So we have a challenge. Going back to the judge, if the court is bound by the advice of the judge, who is not a member of the panel, who is making this decision? And I say this, I have said again, I will not. It has nothing to do with the character of the individual. It has something to do with the structure of the law. If indeed my learned friend's advice is binding, why is there a panel at all? So, Mr. Chairman, I want to pose a question. The judge advocate's power is in Regulation 63. Whether Regulation 63(2) and 69(2) of the UPDF rules of procedure regulations are consistent with Article 28(1) of the Constitution. Honorable Chair, Article 137 of our Constitution deals with the interpretation aspects. The interpretation of the Constitution can be done in two ways, one by way of petition, the other way by way of reference. Even the one of reference has two limbs. One where the court itself considers it necessary, if in its opinion is a substantial question. But the second one is where the party to the proceedings requests for the reference. The word used is that the court shall refer If any party to the proceedings request, the court shall refer the question to the Constitutional Court for a decision. When that reference is made, the case will be disposed of in accordance with what the Constitutional Court has guided. Mr. Chairman, a fourth question arises. Perhaps this morning also. And it has to do with Section 208 and Article 79.1 and 129.1 of the Constitution. We want to ask the question whether that Section 208 is contrary to and contravenes Article 79. 1. Parliament makes laws for Uganda. For the governance of Uganda. Parliament doesn't have power to set itself outside, even 1 centimeter outside the boundaries of Uganda. We contact 129.1 has to do with judicial power being involved in Uganda. So, in our view, Mr. Chairman, it is a question that we want to be interpreted. The place of Section 208 and Parliament. Honorable Chair, the framers of the Constitution, who incidentally also include one of the accused persons, envisage that at one point, as life goes on, there may arise a contestation between individuals and the state, and organs of the state. That is what this 137 is all about. So, Honorable Chair, as I end, my colleagues will supplement on other questions, but as I end, it is our contention that there are very serious questions that have arisen, which on the face of it, and this is the only requirement of the authorities, on the face of it require interpretation of the Constitution. They are not before a field court martial because that is the only time, that is the only court where you can't make a reference. All other courts, you are allowed to make a reference. The party is empowered to make the request. When they do so, the court shall refer the question. I pray that the 4 questions that I have posed be accepted and the reference be made on those and any others that my colleagues may add. Mr. Chairman, before I sit down, I also want to draw the attention of the court to another law, the Human Rights Enforcement Act. The Human Rights Enforcement Act is now Cap 12. In Section 11, the consequences of derogating from non-derogable rights of the council are spelled out. Those who do so commit offenses. That's the first consequence. And as far as that consequence is concerned, the offense, even 10 years later, the person who committed it can be charged and is liable to sentence up to 15 years. When derogation is brought to the attention of the court, that's the second consequence. The court required to declare a trial a nullity. It's a heavy burden. It is a serious issue. So if we try civilians, contrary to Article 28, non-derogable right, in the face of decisions of civilian courts to which we are subordinate, we are committing offenses. In fact, the court is required to declare that trial nullity, acquit, and discharge the accused. The defense forces are capable of abiding by the Constitution and human rights and procedure. This court, I am sure, is capable of abiding by the Constitution and the human rights and procedure. And I invite it to do so. We must respect. Mr. Chairman, I'll invite my other colleagues to supplement, but that is how we are this morning.
Thank you, Mr. Chairman. I'm adding Mr. Chairman for emphasis, and my colleagues will come with questions. Mr. Chairman and members of the court, the first question my colleague raised, I agree with him entirely, was with respect to the uncertainty of the offense, whereby when you do and do not do, you commit an offense. So if we are crossing the road, essentially we have an officer saying don't cross, so that when you cross, you are disobeying an order. And you have one on the other side saying cross, yet when you cross, you disobey again. The point I'm making, Mr. Chairman, is that the necessity for a law to be clear, not only to members of the distinguished EPDF, but everyone, is just so that they know when they are conducting their affairs, when they are out of the law or within the law. And for emphasis, Mr. Chairman, again in the case of retired Captain Arnold Biagala and others versus the Attorney General, concern of petition 44 of 2015, the court addressed itself. I'll just refer to a short quotation so that I can emphasize. Citing an American case, Colenda versus Lawson, the court was of the view that, as generally stated, the void for vagueness doctrine requires that a penal statute defines the criminal offense with sufficient definiteness that an ordinary person can understand what conduct is prohibited and not prohibited, and in a manner that does not encourage arbitrary or discriminatory enforcement. The rationale, Mr. Chairman and members of the panel, is that I should know whether to cross the road or not to cross the road is an offense. That was an example. But also, it is intended for an ordinary man. Mr. Chairman, in society we have individuals who are high up there. We have individuals who are in the middle, who we ordinarily refer to as reasonable. They are not far off. And then we have the others who are lower, who in different aspects are referred to as the riffraff of society. The requirement for a law to be certain lowers itself to the lowest in society. The law should be very clear that an ordinary person the lowest in society is very sure about how they are going to conduct themselves. And that submission, that offense, which says to do anything or not to do anything that constitutes or compromises the security of the defense forces, means that I am effectively at a cross junction. I don't know whether to go left, right, north, south, east, or west. The other one, the third question my colleague raised was in regard to the court being in Kashmir. Mr. Chairman, the courts have recognized that military courts, like the one we are in, is intended to charge or to try officers for disciplinary matters. Of course, in our UPDF Act, there is a clause which brings in the civilians. But again, Mr. Chairman, the courts have made a pronouncement about the character of the military court, it being appointed by the executive, and therefore the officers forming the courts being subject to the executive. And the courts have made it clear in the case of the Second Lieutenant Ambrose Ogwan versus Uganda. It says that courts which have to try any civil or criminal matter must be independent. The command under Article 28(1), and the courts have said by virtue of the appointment of the military court is not independent. Mr. Chairman, we are not making people referring to the individuals because who are before us, or before whom we are standing, because we know that there is an appointment and they are executing the lawful mandate of their appointing authority. So it's not character of individuals, it is the institution, Mr. Chair. Because I've said military courts are not independent, and that they are military courts of the executive, they belong to the executive. Moreover, the charges they try are brought by the army. And Mr. Chairman, the court made reference to two sets of people. Those who are not subject to military law, I suppose like me, and those who are subject to military law. I reckon, Mr. Chairman, like yourself, Mr. Chairman, and the officers before us, because they are soldiers serving, being a national duty of protecting our country. But it said that persons who are subject to military law, like every other person in this country, enjoy fundamental rights which may only be limited in the manner allowed by the Constitution. He said that judges of independent courts cannot be under the administrative control of the authority that brings the charges. In this case, my Lord, Mr. Chairman, rather, to the extent that the court is of the institution of the UPDF, and the offense that has come, one of which is to compromise the security of the UPDF. Again, it shows that the institution which placed all these gallant officers in their offices, in the executive, is complaining before them. Put simply, because, Mr. Chairman, I'm a parent, I have a grown-up child, and I am offended by my neighbor, Mr. Kalibala, and I constitute a panel of my children to try the matter where Mr. Kalibala is accused. And the Constitution, which my colleague has repeated many times, is superior to the gallant forces of the UPDF, commands all courts, including this one, to frame a question and forward it to the Constitutional Court. It does not allow this court the opportunity to determine whether there is sense in raising that question. because that is not disputed. To determine, upon response from our colleagues, that we can examine the validity of that question, or if in their view, the question has been heard before, is to defeat the Constitution. Mr. Chairman, Article 3 of our Constitution says that anyone who acts in breach of the Constitution creates a very big offense, which perhaps, again referring to Mr. Walimbwa here, will now bring him under his court, it is treason. So, we are urging the court, Mr. Chairman, that once we raise the questions as we have done, the honor or the duty of this court is to put the question in proper wording and send them out, and not to determine whether the questions should be sent, because the duty that has been done already, there has been a request. Mr. Kalibanda also referred to the Enforcement Act of Human Rights and said derogating from a non-derogable right, Mr. Chairman, is an offense. That should be Section 11, and that is true. As officers of court, Mr. Chairman, we do have a duty, perhaps akin that of the judge advocate, to advise the court. It is a duty we hold court as officers of court. What Mr. Kalibala did not say, Mr. Chairman, is that while people executing office have got immunity of office, this particular act waives that immunity. So, the judge advocate, if it becomes aware that this court is deviating from it's not part of the court. If any of us became aware that we are deviating from a non-derogable right, we are committing an offense. And that offense is alive for between 10 to 15 years. Moreover, the defense that I was acting under instruction does not arise. Mr. Chairman, in 15 years, I will be nearing 65. So I wouldn't want my younger colleague here to keep it in his heart and after 14 years come against any of the distinguished officers there to say on the 14th of May, he took the view that they were derogating from a non-derogable right. Because the defense of saying we are executing our mandate of officers established under an act of law will not be available to distinguished members. That is the command of the law. Our request, Mr. Chairman, seeing that my colleague referred to the attributes of a force which is patriotic, which is disciplined, and a disciplined individual or institution agrees with established rules and principles, and given that the same command the force to subject itself to civilian authority, we do request that as commanded by Article 137(5)(b), which directs the court to submit the question, that when my colleagues have raised the questions, we do not engage, Chairman, when most politely, we question as to whether we should refer, rather, to spend the other part of the day by getting the right language of the questions, which are then be referred to the Constitutional Court to interpret as they are mandated to do under Section 1, Article. Mr. Chairman, again, and for my colleagues from the state, led by the prosecutor, we just want to refer you, when I say my God, it's not derogatory, the court, to Section 195 of the General Court Martial, which spells very clearly and succinctly the functions of the General Court Martial. My Lord, Mr. Chairman, that section has 3 subsections, and the first subsection has got 5 paragraphs, none of which can't give this court power to interpret provisions of the Constitution or of the other law. Therefore, request that surrender to even accuracy place this court, and the questions be crafted with the aid of our colleagues and ourselves, and sent to the higher court for the next interpretation, so that if we are to return here following the finding of that court, we are sure that all the doubt we had about the jurisdiction, about partiality, about extraterritorial effect, which are now the pending points, are handled, and that we can proceed peacefully and in a manner that is subject and under established law. That is my request. I thank you, Mr. Chairman, members of the panel, for listening.
Thank you, Mr. Chairman, honorable members. The 4 issues framed by my learned friend here are well canvassed by my colleagues here. Permit me, Mr. Chairman, to add on to those 3 issues. But before I do so, Mr. Chairman, just 1 to 3 minutes to reinforce the 2 issues, the first 2 issues Counsel Kalibara raised with authorities on this. The arguments have been adequately canvassed, and we are convinced this honorable court is persuaded by those submissions. Now, with authorities on vagueness of section 128, that is issue number 1. Vagueness, the uncertainty of that particular provision. The Constitutional Court has had occasion to pronounce itself on that particular matter in the case of Andrew Karamagi. I'll furnish you the copy with you. Rather, I'll furnish you the copy. Andrew Karamagi, Robert Shaka versus the Constitutional Petition number 5 of 2016. But the point emphasized here, Mr. Chairman, the doctrine of vagueness. This is what they said on page 10. This is the Constitutional Court. The doctrine of vagueness is founded on rule of law. The doctrine of vagueness is founded on the rule of law, particularly on the principles of fair notice to citizens and the limitation of enforcement discretion. Fair notice to the citizen comprises a formal aspect and acquaintance with actual text of a statute, and a substantive aspect, and understanding that certain conduct is subject to legal restrictions. The crux of the concern for limitation of enforcement is that the law must not be so devoid of precision in its content that a conviction will automatically flow from the decision to prosecute. The threshold for finding a law vague is relatively high, and this is what they set as a standard. The factors to be considered in determining whether the law is vague or not: A, the need for flexibility and the interpretative role of the courts, that is number 1. 2, type of integrity is critical and crucial. 3, the possibility that many varying judicial interpretations of a given disposition may exist and perhaps coexist. They cited the case of Nova Scotia Pharmaceutical in
it is a 1994 decision which you will find here. So the doctrine of vagueness can be summed up in one proposition. This is how they summed it up, the Constitutional Court. A law will be found unconstitutionally vague if it lacks in precision as not to give sufficient guidance for legal debate. That is, for reaching a conclusion as to its meaning by reasoned analysis applying legal criteria. The term legal debate is not used. The term legal debate is not used to express a new standard or one departing from that previously outlined by this court. It is rather intended to reflect and encompass the same standard and criteria of fair notice and the limitation of enforcement discretion viewed in fuller context of analysis and quality and limits of human knowledge and understanding in the operation of the law. The criterion of absence of legal debate, and so it continues and continues. And finally, Mr. Chairman, this is the decision they arrived at after analyzing all of that. The statute is also void for vagueness if a legislature's delegation of authority to judges or administrators like this General Court Martial is so extensive that it will lead to arbitrary prosecutions. I need to emphasize this. The statute is also void for vagueness if a legislature's delegation of authority to judges or administrators is so extensive that it will lead to arbitrary prosecutions. Vague laws involve very basic dangers, and this is what we want to caution against. This is what they say. Vague laws involve very basic dangers. One, they may harm the innocent by failing to warn of your offense. Ignorance of law is not defense, yet the law itself is vague. Two, they encourage arbitrary and discriminatory enforcement because vague laws delegate enforcement and statutory interpretation to individual government officials. Laws are usually found void for vagueness if after setting some requirement or punishment, the law does not specify what is required or what conduct is punishable. Also, an enactment is void for vagueness if its prohibitions are not clearly defined. Finally, Article 28(12) is very clear. It requires that an offense must be defined. That definition, in my view, must be clear enough for the citizens to distinguish between the prohibited conduct and the permissible one. Any vague interpretation will lead to satisfy the requirement of Article 28. In fact, the case of Charles Onyango versus the Attorney General. So this authority by the Constitutional Court, which has got that primary obligation of interpreting the Constitution, is binding. And it's very instructive in that when you look at Section 128, it opens floodgates. It cuts the net wide offenses relating to security. And punishment, this is how serious it is. So a vague law to subject somebody to a death penalty is something that cannot be sanctioned by the existing constitutional order. And the reason we are asking, we need interpretation of the constitutional court about that particular provision. So that is the authority in regard to the vagueness of Section 138 relating to offenses compromising restricting civilians to martial law, which my land friend here adequately canvassed. But the authority, and he cited a number of authorities. He cited the ones of Uganda Law Society, cited Amuli Yagaba, and cited Kwazulu and a couple of others. But the point I wanted to emphasize, there are two authorities that have come subsequent to the decision of Kwazulu. The one of Amuli Yagaba, which is 2022, and it was very, very clear. And on that one, there was an appeal. The one of Yagaba. Yes, the Attorney General appealed, preferred an appeal. against the decision in the Karasburuka matter. But the one of Harmony Gam, there is no there is no any other state and no any other far order than that region. My other friend alluded to the fact that the other side may raise a contention that there was an order of stay in the Karasburuka case. That has also been subsequently handled by the Constitutional Court, which took a decision in that case. They have decided one in the case of Harmony Gava, but more sufficiently in the case of the same Jew, Abdul versus the Attorney General, Constitutional Petition number 4 of 2018. The most recent one, it is, to be exact, it is the 3rd February 2023. It is as fresh as his charges before him. This decision, the lead judge, may his soul, Justice Kakuru, may his soul rest in eternal peace, had the occasion to reproduce verbatim the decision in the Karasburuka case. Sum them up, and he said, the constitutionality, no, I have carefully listened and considered the submissions of both counsel on the constitutionality of sections 119 and 197 of the UPDF Act. I have also carefully perused the affidavits and so on and so forth. The constitutionality of the issues raised above were substantially raised and settled in the recent constitutional decision of Honorable Michael Karasburuka versus the Attorney General. That is constitutional petition number 45 of 2016. Then he said, I will produce the declarations in extension for clarity. He highlighted them. I will not take your time, but they are very few. Yes. Yeah, just number 5. No. The General Court Martial established under section this. No, number 2, the General Court Martial's jurisdiction is only limited to trying service offenses under the UPDF Act. Then, he said, Article 3, military law under the UPDF Act must be construed to exclude laws that are the preserve of the civil courts of judicature. I will come to that later when I'm raising another issue. But more specifically, number 4, person is subject to military law. No, 5. Sections 119, 1H, subsection 1 of section 179 of the UPDF Act are unconstitutional as they are inconsistent with Article 28 of the Constitution. That is a finding which is well captured in the decision of Karasburuka and reproduced in a number of those decisions. And they had occasion to make this finding after listening to the submissions of the state that in the Karasburuka matter, there is an appeal, there is an order of state. This is what the Constitutional Court said after listening to the submissions, which are likely to come from the other side when they are replied. This is the response and the finding of the Constitutional Court. The above authority is good law, and I am bound to follow it. We are well aware that the above cited decision is currently pending appeal at Supreme Court. Until the Supreme Court decides otherwise, the authority is still good law. The fact that gave rise to this petition are almost on all fours with those in Honorable Karasburuka's case. Applying the above authority, I find that the petition is on all fours. The petition is therefore allowed on that account alone. The same declarations and orders in the Karasburuka petition apply to this petition. This is as of recent as 2023. So, this court, I'm afraid to say, its hands are now packed. Has no choice but to go by the declarations of the Karasburuka decision and reinforced in the decision of Semuju and Yabgaba and others which have come subsequent to the one of the submission I will make here. Again, in emphasizing the point Fred Mbange here has raised of Article 3. Any attempt by this General Court Martial to proceed with the prosecution in total disregard of this finding of the Constitutional Court, with all due respect to the General Court Martial, it will be treason. It will amount to treason for this General Court Martial to proceed with the prosecution, with the hearing of the matter, in total disregard of this, because the Constitution Article 3 is very, very clear on the observance of the constitutional order, respect to the given constitutional order and interpretations. So I urge you, Mr. Chairman, members of the panel, not to commit treason by proceeding with this matter. Now, Mr. Chairman, with your permission, I beg to move and frame three issues. The first issue, in addition to the ones, the first one is about the propriety of the proceedings, the charge sheet canvassing Mr. Chairman. Mr. Chairman, whether the trial premised on arrest and rendition of accused persons from Kenya in total disregard of the extradition law and other international laws, and on the basis of a memorandum of understanding which is not within the framework of the extradition laws, amounts to a violation of Article 28 of the Constitution. Mr. Chairman, in your finding this morning, you indicated that there is an MOU between the government of Uganda and Kenya to exchange people presumed to have committed offenses, which obviously is not premised on international law or the existing extradition acts or laws,